Well, the issue is like this. Now with the electronization and computerization of the returns of income, one cannot file return of income except as and by way of uploading the return. Physical forms have gone away. Secondly, I can file return of income only according to their prescribed format. What is happening is this. Up to 5th July 2024, they permitted income tax payers to file return of income claiming rebate under section 87A. So I need to step back and go a little historically. In order to give concession to small tax, let me clarify where I am actually going. They are not permitting returns to be filed making a claim for rebate. Now, whether I am entitled to or not would be decided at the stage of assessment. How can revenue devise a form whereby SS is prevented from making a claim? That's the short question.
How can it be a question of public interest?
Because this is a case of lakhs of small taxpayers. It concerns only those taxpayers where the rebate amount.
Individual taxpayer can always come forward and say that he has been deprived of claiming rebate and this is causing prejudice to him. But this cannot be a matter of, we are not the policy makers.
I'm not requesting the lordship to get into policy at all.
Yes.
And
why form has not been provided, why that column is not there, cannot be subject matter of
if in law an SSC is entitled to make a claim,
then that particular SSC can always come to the court and say that I have been deprived of the claim.
Amount will be 300, 500, 700.
Maybe 2 rupees.
But
people can come to the court.
Can I request a lordship to look at 2004 volume 11 SCC page 1 on the locus standi?
No, it's not about locus. It's not about locus.
Yes, then I will not cite that.
The policy it's about the prayer which you are making in the repetition.
Yes.
Grant this prayer in PI.
Well, let's look at my prayer. But what is it that I am requesting the lordship to consider?
We cannot ask the department to
I would restrict myself
to provide some space for that. But that you can raise individual dispute before the department.
No, okay, I'm sorry, it will not be possible. I don't know why it will not be possible.
No, you can always write to the higher authority. Come to the court. But this is the prejudice which is caused to you.
The requests are made to the highest authority by Institute of Chartered Accountants.
The individual person can come in the relevant jurisdiction and the court may ask for the reasons.
But if I have locus standi, obviously lordship will hear me.
No. It's not about
the locus standi.
What do you mean by locus standi?
With the PI, like the instance of a person who is not.
No, we are not on that question. We are on the question that the issue which you are raising as a matter of PI is a policy issue which does not show any prejudice caused to any person individually. And the individual person to whom prejudice is caused can always approach the court.
No, I'm answering the first aspect of the lordships. How does it cause prejudice?
We don't know.
Well, that's what I'm trying to explain.
The individual person has to come forward that this is causing prejudice to me. I am entitled for the rebate. It's not a question of deliberation.
I'm not.
Everyone who is entitled for rebate.
Please consider the aspect he is not permitted to file return of income.
So then he should come forward and approach the court that this is how he has been deprived. Of the benefit of the Income Tax Act. That particular person can come to the court.
But a particular person can certainly
be issued.
A particular person can certainly come. Instead of a lakhs of SSCs or some of the lakhs coming to a lordship.
1 or 2 will come, the court will pass orders, everyone would follow.
That's what I'm submitting.
See, 1 or 2 can come. And then this would be kind of an order which would be ordered in advance. Then they have to follow. But it is not a question of PI.
If PIL is maintainable, lordship will examine it. If a lordship
what we are saying is it's not a question to be taken in PI, it's about the implementation of statutory provision. It is about deprivation to a particular individual of the right, which is a statutory right.
Correct.
So for asserting statutory right, that person individually has to come to the court.
For that I'm submitting this right, my lord. Please consider this aspect from this angle. I am putting across case for persons who would have claim of amount ranging from couple of 100 rupees to couple of 1,000 rupees. So small people may not be in a position.
Everyone can come. It's not necessary that.
I'm not saying that they are not entitled to come. Question is whether there would be two. They would have no reason to come for 100 rupees, 200.
Of an individual person believes that I have a statutory right to claim rebate. It's about you or many persons who are individually affected.
So far as this person, petitioner is concerned, he would not be.
Income tax and income tax rebate is an individual right.
So it's an individual right. But can government devise a form so as to disentitle person from making the claim?
No, we will look into once you come in an appropriate jurisdiction. We will call, we will ask for we will make inquiry We will ask for the.
Is it permitted to clarify as to why this is not correct?
It may not be correct, but what we are saying is that this is not a matter of PIL. This is the why we are saying so. We are saying so because of the fact that the right which you are claiming in the PIL is an individual right of an assessee, a particular assessee.
Ultimately, what is that?
Ultimately, what is happening is not
ultimately what is PIL. PIL is in a proxy litigation on behalf of those who are unable to litigate because of the smallness.
Not the
public interest litigation, the litigation for the benefit of public.
And there is no Article 1421.
When I was trying to rely on this judgment of the Honorable Supreme Court, where a chartered accountant approached the Honorable Bombay High Court, challenged all banks who were not granting refund of interest by rounding up the money. Issue was of fraction of a rupee. In the Honorable Supreme Court,
that must be generally applicable to everyone. But your rebate can be claimed by few.
No, but it can be claimed by every tax assessee who is entitled to benefit under Section 87A.
Right. So only those who are entitled to benefit under Section 87A.
But that in case of our Supreme Court judgment, it is available to those only in whose case rounding up has taken place by the banks. If the rounding up has not been done, even that would not apply. Therefore, the fact that it is applicable to only those who are covered by the legislation with respect may not really be a reason. Not covered, but then there are lots of hear me and then lots of it. So please have a look at this 2004 Volume 11 SSC case one. And we go to page 17. There are 32 onwards. Locus of the respondent. The petition to the High Court was a firm of chartered accountant as an expert in accountancy and audit law. So there are 32. Page 17, there are 32. The petition to the High Court was a firm of chartered accountant as an expert of the include action of the appellants. By reason of such an action on the part of appellants, as also Reserve Bank of India, as noticed herein before, citizens of India have to pay a higher amount of tax as also a higher amount of interest for no fault on their part. They will be recovered from them without any authority of law. By entertaining a public interest litigation, this court in exercise of 26 under Article 32 of the Constitution and High Court under Article 226 thereof are entitled to enter in a petition moved by a person having knowledge in the subject matter of the lease and thus having an interest therein, as contradistinguished from a busybody in the welfare of people. Rule of locus has been relaxed by the courts for such purposes with a view to enable citizens of India to approach the court to vindicate legal injury or legal wrong caused to a section of the people by a violation of any statutory or constitutional right. In fact, courts have been treating a letter or telegram sent to them as a public interest litigation by relaxing procedural laws, especially law related to fees. We did not dilate further on the subject at the bench of this court. In so and so observed, quote, the courts exercising the power of judicial review found to their dismay that poorest of the poor, deprived, illiterate, urban and rural, unorganized labor sector, women, children, and those handicapped by ignorance, indigence, and illiteracy, and that the downtrodden people have either no access to justice or have been denied justice. A new branch of proceedings known as social infection litigation or public interest litigation was evolved with a view to render complete justice to the aforementioned classes of persons. It expanded its wings in course of time. Courts in pro bono publico granted relief to inmates of prisons, provided legal aid, directed speedy trials, maintenance of human dignity, and covered several other cases. Representative actions, pro bono publico, and test litigations were entertained in keeping with the current extent of the justice to the common man and the necessary disincentive to those who wish to bypass the real issue on merit by suspect reliance on peripheral procedural shortcomings. Court in pro bono publico proceedings intervene when there has been callous neglect to the policy of state, lack of probity in public life, abuse of power in control and destruction of the environment. It also protected inmates of prisons and homes. It's not
this matter, the grievance was raised by a firm of chartered accountants.
Yes.
Like they were raising no issue with regard to their personal interest.
I have no personal interest in the matter.
We don't know who
I'm saying the repetition. That lordship will find in the repetition. Please go to the repetition.
You are an income taxpayer.
I'm an income taxpayer. I'm not affected by this.
So why would you come?
Because in the larger public interest.
No, you can't. You don't have any expertise.
I'm a chartered accountant dealing in the field of taxation. I'm sure lordship would not have any reservation about the knowledge of chartered accountant in the field of tax law.
We don't have any reservation about that.
Now, what is he? Question is lordship question, who is he? Please go to paragraph 2. Page 4. The amount which they had
already filed return.
Those who had filed returns of income before and
now they are able to claim benefit rebate under Section 87A because of this software. Correct. This is the only issue.
Correct.
That issue can very well be raised before the tax bench by an individual that he has been deprived of claiming this rebate and is falling in the category, and he has submitted his return in time up to June 2024.
The fact that it can be raised individually by taxpayer.
For us, it becomes an academic issue. But Mr. Sabarkar, please try to understand.
Yes.
The PIL deciding an academic issue that too relating to application of a statutory provision granting rebate to a person is not possible.
I am not asking.
We are not raising objection for the sake of raising.
I understand your logic perspective. I am trying to explain.
I have to understand our difficulty. I will not be able to execute.
The main part of my submission is lordship has relegate me to the tax bench. Right? Don't matter what it is.
This person.
If necessary amendment I join. But please consider the issue.
Yes, you can withdraw this. We will permit you to file a proper petition by a person who has actually been deprived of getting this benefit because he is not being able to enter the relevant field in this software. See, he has to make out the case that he falls tentatively, prima facie he falls within this scope of
Section 87 rebate.
And he is entitled at least to claim the rebate. He may not be entitled for the rebate, but claim can be put up.
It is a return can be uploaded. How can they deny me making of a claim?
You are, Mr. Parker, we are feeling a lot of constraint at passing any order in this PIL. But had we heading the tax bench and the person would have been there who has been deprived, we would have immediately asked for the response.
But probably the handicap is not actually there. That's what I'm trying to understand.
Please, Mr. Parker, please try to understand.
Yes, ma'am.
Deciding academic issue in any petition is a real individual claim. We could have adjudicated it.
But just give me 2-3 minutes. Please see in this regard.
No, just purely academic issue for the PIL.
But please kindly go with me for 2-3 minutes. Please go to page 35.
We are not about locus. We are about.
Please go to page 35. A detailed representation is made by Bombay Chartered Accountants Society on 18th July 24. So, issue that I am raising is not an issue for the sake of raising. 18th July 24, Bombay Chartered Accountants.
All these preparations are made for the PIL.
But PIL
representations are prepared for the purpose of filing PIL. Many a times people do that.
Page 40. Representation is made by.
We are not having any kind of doubt about the intention of the petition. We do not have any doubt about the competence of the petition. We do not say anything about the locus. What we are saying is that this issue which you are raising is an academic issue for the purpose of PIL. This issue can very well and effectively be raised, but before a competent bench by a person who is affected by this new software, and that can be.
But would you get the prayer that I am making? I am going to insist for my lord's consideration one prayer only. Please go to page 20.
Too many prayers for a PIL.
No, but I am going to rely on prayer C and or G. Permit me to make a claim. Whether I succeed or not would be a single
one SSC can come forward.
Please see, let's look at the petition. One of the SS in the present case, he is denied the benefit of rupees 227.
That does not matter. For fighting for a cause, he can spend some money.
But he may really not be
6 persons can join together.
227 multiplied by 6 will be 1500 rupees. That will also not lead us to a significant amount.
We are feeling a lot of constraints in deciding this.
Yes, but just try to ascertain from the revenue why are they not permitting.
Then again, that means we are entering into an academic issue in a statutory right which can be agitated by an individual who's deprived of that right.
Just give me 1 second. Let me find it and check out whether I can withdraw with a liberty. I don't want to withdraw my own unless previous degree. Just check. I'll be there on the perfect. Serial number 16. This is one big matter. Instruction document permit me to withdraw, keeping all contentious open, including right to more learned appropriate court under the provisions of the Act.
After a brief submission from Mr. Saurabh Sabarkar and senior advocate, assisted by Mr. Rebate U, an advocate appearing for the petitioner, would submit that the issue raised in the present petition may be permitted to be raised in an appropriate petition to be filed before the consent tax bench. In view of the said, please for his withdrawn. Present petition may be permitted to be withdrawn with liberty to raise the issues by an appropriate person before the appropriate tax bench. In view of the said statement, the present petition is dismissed as withdrawn with liberty to the concerned person to raise the issue. The contentions in the petition and the merits of the issues raised in the
Immense obligation. Right, right.